have three people here that I'm going to try to lead through these questions. One of them asked me questions in first year. Of course, that's Professor Peter Hogg. One of them I never had a chance to be asked questions by, and that's just because I didn't stay at the law long enough to get to any court where she was sitting. And then the final one, of course, Michael Bryant, I asked questions of in the legislature, and I learned there why they call it question period and not answer period. Anyway, question one, and we're going to try and do this in a little shorter time than was allocated just so that we can keep the program moving. And the question one came from Nicole Walton. Nicole, where are you? Because I'm going to let you ask your own question. Where is Nicole? There you are, right there. Okay, I'll come down there and let you...
Good afternoon. What do you think is the most important change necessary to improve access to justice for middle-class Canadians? Do you think that the entire legal system requires change, or should the legal profession adapt from within?
Now thank you, Nicole. We had a very short meeting and agreed that Peter would answer every question first, and that's because he said he was unimaginative, and it would give the others time to think. And Madam Justice Rosie said that it's because he had an answer ready with everything, and that it would be in 5 minutes. But in fact, Peter said it would be 45. But we'll make sure that doesn't happen. Peter, over to you.
I can demonstrate that I am the unimaginative group of the unimaginative member of the panel when you look at the socks of the three people. And
it's true. It's embarrassing.
He wore those in the legislature, and we knew it was just a distraction.
But that may make my answer a little bit of a puzzle to this question, because I say, occupy Bay Street. That's the answer. Reduce hourly rates, speed up court proceedings. Those are the kinds of things that have to be done. That all assumes, of course, that we will have an ongoing middle class, and there seems to be a long literature developing now about the disappearance of the middle class, in which case I suppose this problem will disappear.
Madam?
That's it?
That's it.
That's it.
Piece of cake. This is going to be fun.
And those are the kind of short, pithy answers we're looking for, Madam
Okay,
Justice.
okay.
I say to you with the utmost of respect.
The idea that these other panelists are not going to do any work is that's just not going to fly.
But this is different. When I hear we're going to do the 4 questions, it has a biblical connotation. So first of all, the question about change. One of my favorite jokes, you know, the light bulb jokes. How many does it take to change a light bulb? So the light bulb joke about how many members of the legal profession does it take to change a light bulb? Change? So I found an article a few years ago written in 1906 by Roscoe Pound, who went on to become a dean at Harvard, but was at the time the dean of the Nebraska Law School. And he was speaking to the American Bar Association. Now remember, this is 1906. And his speech was called Public Dissatisfaction with the Civil Justice System. And what he wrote about was how expensive it was, how technical it was, how adversarial it was, how impossible it was to get a result, how law had become a trade rather than a profession. And what it showed me, aside from the fact that we're still talking about these issues over 100 years later, is thought about how people got to what the rest of the world was like in 1906 when he gave his lecture. We used leeches for medicine. People got to the lecture by horse and buggy. I don't know how we listened to music, but everything in the world was different in 1906 than it is today, except how we conduct trials. If you took a lawyer from 1906, aside from how shocked he would be about seeing a woman judge, it would be very easy to train him in a couple of hours to feel comfortable in a courtroom. And what I've never understood is why we're so reluctant, uniquely, to make the changes that are necessary to give people access to justice. If the medical profession has not been afraid to experiment with life in order to find better ways to save it, how can we say to the public, we can't experiment with justice? Justice is just something that we have to protect and trust us, we know what we're doing. And it's amazing to see how even alternative dispute resolution, which was meant to be the answer to what they actually came from, I think, the 1977 Pound Revisited Conference, where they said, how far are we since 1906? So they came up with the ADR, and it's like an elastic that can't change shape. ADR has become a procedural mimic of what goes on in the courtroom. So should it change? Of course it has to change. I don't know why we're not changing it. I don't think the rebuttal, we've always done it this way, is an analysis. There must be better ways, and we have to look at profound reform, I think, from the ground up instead of looking at it from the top down. So you may not have been expecting a serious answer, but I'm going to end with, today is, they're dedicating a memorial to Martin Luther King in Washington. And he had a quote in 1961, 50 years ago. That was really quite wonderful. The arc of the moral universe is long, but it bends towards justice. And the next sentence is, but you have to help it bend to get there. So I think we've just got to stop having this conversation about things that tinker around the edges of the problem, like ADR, like better pro bono, like better legal aid, all of which is important, and just start talking about, if we were designing a system today, what would it look like? So I think we do have to change it.
All right. Michael, you've been in one of the places where change can be brought about, not the only place, but over to you.
Yeah, I think that the justice system as we know it is going to shrink. I think that there will be innovation through software, through insurance products, consumer-oriented, true alternatives to the justice system. I think it'll be somebody more like Stephen Jobs than a judge or a lawyer or a law dean that brings about alternative legal service products. And if you look at, just to take Jobs as an example, in Apple, the change to the music industry that was so radical in terms of getting it and also publishing it. And it all happened so fast. I think the only question is whether or not the legal profession will be a part of this innovation or will have it done to them. So I think you'll see paralegals playing a greater role. As I said, technology will be playing a greater role. I think that there will be alternatives that are business-driven alternatives. And within the legal profession itself, I think this, if I could pick one thing, because the question was if there's one thing we could change, it would actually be around insurance products. If you think about the personal injury system in our automobile system in Ontario, as imperfect as it is, it's a part of the justice system. And if you're in a car accident and it's more than a fender bender, you're in the justice system suddenly. And yeah, it's very imperfect, but it doesn't bankrupt you, and you do get something, however imperfect it is. Outside of that context, if you are involuntarily thrust into the justice system, it can bankrupt you, or you don't get any access. So I would have thought that the legal profession, maybe government, in combination with government, and the insurance industry needs to start offering products that will allow people to actually access the justice system, because right now, it's not actually so much that the system has priced itself out of the market, it's just the market has changed, and the middle class has not grown along with those fees. And thus, you have a system that's really irrelevant to most people. It really is irrelevant to most people until they find themselves on the other end of it.
You know, one of the things that, can I just follow up with this? If you see that the purpose of adjudicating disputes is to get to a result, and people can't get to the result, there's no there. You know, what's the point of having this whole elaborate, fancy system if people can't get to where they want to go? So, in my ethics, we had a 1-hour ethics lecture from Bill Gale, who was then the Chief Justice in the Bar Admission course, and there were like 15 women and 500 men. And I remember what his ethics lecture was. He said, men should never wear brown suits with white socks. And I think you've taken that lesson very well. No white socks.
No comment. Can I just say, you know, one of the things that ties together two of your answers is that people like Mr. Jobs and people like, I work for Ted Rogers, one of the great Canadian entrepreneurs, and they would not accept the words, we've always done it that way. They were the words you were not allowed to speak because they were agents of change, and it involves resisting that. Speaking of changing, Dean's sitting here, but that's okay. He made me the moderator. I'm going to change the order of the questions because I think the next one follows on not only the discussion we had from some of our other honorees and guests earlier on, but maybe just what we're talking about here. And I'm going to ask, where is Jacqueline Kigundu? Jacqueline, where are you? There you are. I'll come back there and let you ask your question. I'm just going to ask it next because I think it logically follows from that discussion we just had.
This is fun.
So for much of Osgoode Law School's history, law students were white, Anglophone, Christian, and male. Today, Osgoode students represent many religious, ethnic, and racial groups, sexual identities, and the ratio of women to men is equal. Much work remains, however, before the law school or the legal profession truly represents the diversity of Canada. What can we do to build an inclusive legal community? How will this diversity change the way that law is practiced in Canada?
And may I just say, Peter, on the way back up to asking you to start, the Civic Action Commission to study this year as part of its diversity project, Ryerson having done the work, and they actually put numbers beside that showed that not just the legal profession in terms of partnerships and so on, but also the judicial system, we're not yet anywhere close to representative of the society in which we live in Canada, and notwithstanding that a lot of people are going through law school and becoming graduates and so on. Over to you.
I do think, though, that the diversity of the law school population does move into the profession and eventually into the judiciary. And so there is a change that is going on, and we always think that it's slower than it should be, but it is inevitably going on. And so the students that leave the law school go into articling positions and become associates and partners, or to open up their own practices, or go into, are starting to mirror the complexion of the law school itself. And so I think the diversity in the law school is profoundly important. It will change the profession and it will change the law. Among the sort of practical things, I now work at a large law firm, and one of the things that they have discovered is that by becoming more diverse, they are becoming more like their clients. And of course, they like that because they can give better service to their clients by people who will get on with each other in a much more immediate and easy way if the law firm is as diverse as the client, and that's often the case. But it also leads to things which I know are criticized as being very inadequate, but for example, you need to have flexible time arrangements to adapt to a diverse working population of lawyers. You need to have obviously things like maternity and paternity leaves, but you also need to have, and I know this is always scorned as a mommy track, but you need to have understandings that some people aren't going to work the same number of hours for a certain number of years as other people will be able to do. Various things like that can be flexible, and law firms, I think, are moving in that direction. And as far as the law is concerned, well, we don't have to look very far to see the enormous impact that diversity has already had on the law. And I'm thinking in particular of the various emanations of equality rights, rights of women that have been spearheaded by Rosie, the rights of gay and lesbian people, which have been enormously accepted, first in the courts, but now more and more in the greater public. and more people are much less often barred from what they want to do by things like their sexual orientation, their sex, their race. And so that, once again, I think probably everybody would say, well, that isn't happening fast enough, but it sure is happening. And so I think we're seeing some wonderful results from the diversity that is starting in the law schools, or it's starting behind the law schools, of course, but that is being represented in the law schools.
Again, the numbers suggest, Madam Justice, that that change is pretty slow to come, perhaps slower than it should be. How do we make happen what Peter talked about, a little faster perhaps?
Well, it's amazing because it's all happened in one generation. I mean, Osgoode came up here in 1968. Look at how the profession has changed since 68. But I looked at the Ornstein report, which is a Law Society report on race and diversity, women and non-whites, Aboriginal people in the profession, and it was breathtaking to see the change in numbers. Remember when Bertha Wilson gave her speech here in this room, Will Women Judges Make a Difference? In 1990, 9% of the judiciary was female. Claire Leroy-Debay wrote an article 10 years later saying some will, some won't. Then there were 22%. Now it's something like 32%. But what is interesting is, even though you have 60% of the profession now women, 60% of the people under 30 are now women, a higher percentage than we had before, but not much of people who are non-white, very little change in Aboriginal people. What you don't have is a serious change in the representation at the top. And I remember the first time I heard the expression glass ceiling, I thought, what does that mean? Because for women, I have to tell you, in my generation, because there were so few of us, we weren't as scary. So we really could do things that we thought we should be able to do, and there was nobody to tell us that we couldn't. The minute it became a critical mass, we started hearing words like reverse discrimination and the merit principle, and all kinds of baggage came with that. And if they were really serious, they wouldn't have children. And you see in this Ornstein report that the wage gap goes way, way up for women in the legal profession. So I think, just thinking about the Globe and Mail editorial yesterday, which was, do we really want to use the term visible minorities anymore? After all, they're all so different. Muslims, people from Southeast Asia, blacks. And they said, and they have nothing in common. Well, they do have something in common. They are disproportionately underrepresented at the senior levels. So I think we've done wonderfully to get women in the judiciary, in the federal judiciary. There's no comparison between what it was when Osgoode first started in 1968. And we're much better in the number of women and minorities who come to the law schools. But for some reason, we talk about flex work, we talk about how there shouldn't be any barriers. The words and the rhetoric are gorgeous, but they're dressed up and no place to go. They don't seem to really genuine have attracted the attention of the profession, and it may be because there's such an endless stream of people ready to come in and take the place of the people who leave, that there really maybe isn't a need, as the profession sees it, to do what it takes. So I see this as sad because you lose people in the profession who would make wonderful contributions. If they really want to go, fine. But we should be doing everything we can to keep as many of the talented people who graduate from these law schools in the profession. And for some reason, even though our numbers have improved, the face is good, the rest of the body seems to have a bit of catching up.
Again, these numbers at this Civic Action Ryerson study showed, I think 4% of partners were from visible minority Aboriginal backgrounds and so forth. I think it was at 9 or 10 in the law firms for women. And so those are numbers that are, and again, you come back to something you mentioned, I call it part of the business case for diverse representation in the upper echelons, because if you don't believe in the moral rightness of it, there's a business case to be made. But in any event, Michael, you've confronted a number of these issues in your different lives.
Yeah, I think like in the large firms, a number of women are voting with their feet. They're seeing that lifestyle as as insane, as literally one that makes no sense, and even from a productivity perspective, that makes no sense. If they wanted to make money, given the hours that they were working in, and given the glass ceilings that are still there, they'd be in investment banking, not in the legal profession. So I think, so what comes of that, right? What comes of women who are leaving the large firms and moving or starting their own firms? I don't know. We'll have to see, but I think that that's a trend. That's about all I can say on the law firm front. On the judiciary and political front, I mean, I think the thing that decision makers and leaders can't ever lose sight of is one half of what Chief Justice Winkler was talking about with respect to opportunity and ambition. On the one hand, you need people like Justice Abella who are willing to answer the calling and are willing to do what's necessary to have that ambition and to pursue those posts that men just didn't have. At the same time, the people who are in the place of making those decisions, which more often than not is the white Anglo-Saxon male, need not get complacent. So, when you look at the career of Roy McMurtry, so many of his appointments were firsts. So many of them were. And he knew he was there, and he was there for 10 years. But during that 10 years, he made a huge difference in terms of the face of the bench. I remember when I first started as Attorney General, Julie Hanningsberg sat down with me, and she was in my office, and she said, let's look at these appointments. Like, we're going to be gone in a few years. We're not going to have this job anymore. Are we going to be proud of this? Because look at this list. It's just a bunch of white guys again. And we had to push back to get people on the lists so that we could make appointments that did reflect the diversity that is out there. So leadership and also ambitions, not quite the word. It's a willingness to take a risk, and which leads me to the last comment. One of the things we found was for a lot of the leadership posts within the justice system, women would apply once, and that was it. So whereas the guy would just keep on applying after not getting the justice job time after time after time, the woman would say, "Oh, okay, so you don't think I'm qualified to be a judge? Okay, I'm out of here." And it meant that we had to adjust the system to reflect that. There's a wisdom in all of that on both sides and on the appointment side, but it also means that more often than not, sometimes it means that the person who is a minority has to display the kind of courage, far be it for me to say, but display the kind of courage that people like Justice Abella have displayed over time. So you need both.
One more thing. Oh, look at that. One more thing has to change, and that is, and I say this often on the radio in the context of politics, women won't go into politics quite often because they can't deal with the disproportionate amount of family management, if I can call it, that they take on, and they have no confidence necessarily, notwithstanding the better attitude of men nowadays, that somebody else is going to pick it up, and they often will say no to running and to taking on, I think, some of these other jobs too. Want to comment, Rosie?
First of all, I think the profession is becoming difficult for men and women. I don't think it's just uniquely women.
Agreed.
It's just that the pregnancy seems to be disproportionately done by women, and so. But can I say something?
Is that new?
Yeah, no, it's under the charter.
Okay.
You have to bring the case. Okay. I want to say something in response to that that Chief Justice Winkler mentioned that I feel totally differently about. And that is this. I actually tell law students, do not have a goal. Because if you have a goal at the end of the day, you will not do things that will be wonderful for you, that might be great fun because you will measure everything you decide to do professionally against the possibility of that ultimate goal. Do I need a better example? Would I have done all the gay rights cases? Would I have done a Royal Commission on Equality? Would I have run a labor board? So if you're thinking next all the time, instead of just taking all of the wonderful things you can get in the fields of the law, I think you're much better off. So I see it as a willingness to work hard, take opportunities as they come along. But the goal can be a straitjacket and can really inhibit you from taking opportunities that might be really good for you because you're afraid that'll get in the way of the ultimate goal.
That actually makes me feel much better as someone who sat in this room and ended up as a talk show host. Thank you.
But a very good one.
Now, I want to give you a little warning of this next question, which I did out of order, but I thought it was logical it should end up in this place after the first two. And I'd ask each to think about, so we can keep the answers short on this one descriptive feature that you will name, and maybe a 20-second answer as to why you'd pick that descriptive feature after we get Erica Keating. Erica, where are you? You're assuming I can see. There you are. Okay, perfect. We're going to get Erica to ask her question. I'm not meaning to give short shrift to it, but I think if people are to the point, it'll answer what you're talking about in terms of.
Okay, thanks. Hi. Many legal scholars criticize Justitia's blindfolds. Others take issue with her sword and scales. If you could create an icon of justice to replace Justitia, what would it look like?
George Clooney.
You've gone out of order. First time I'm able to bring a Supreme Court of Canada justice to order. Peter?
Well, I wouldn't change a thing. I think she should be a woman. And I think the blindfold signifies that the judge has got to try and be completely neutral, uninfluenced by wealth, power, etc., etc. The scales, I think, are great because the cases that come before judges are difficult, and the idea that the arguments on each side should be carefully weighed seems to me to be absolutely right. And the sword's a little harder to understand, but I understand it's a double-edged sword, and so it can be used to enforce a decree in favor of either side. So I think it's pretty good, and I think that if we tried to change it, there would be some kind of fateful blow from the gods, because I think this all comes back to Greek and Roman myth, and we really shouldn't mess with that at all.
All right. Madam Justice, your turn.
Well, it's an amazing thing. I never thought about the fact that she had a sword before. I'm not even sure I noticed that she had a sword. I did notice that it was a she. And it's an amazing thing when you think about it, because it was a she from Greek and Roman times.
Yes.
And it remained a she all the way along, even though judges couldn't be women. I mean, interesting how justice personified as female, but judges weren't. So what would I change? I think the scales mean she's at Weight Watchers, don't you?
Well, one of the, I must confess, I went to Wikipedia, and one of the prominent depictions of Justitia is a 16th century woman, full frontal nudity, beautiful woman. She might be watching her weight.
Do you know they changed the statue in, where was Charles Schultz? Charles Schultz, the guy who did Peanuts? Mm-hmm. At his university, they did a new statue of Justitia in the shape of, in the form of Lucy, with a big smile on her face. So, so the sword is an interesting component too, because you know, Solomon had a sword. The idea of using a sword to enforce your order, I guess it's a little more dramatic than having an injunction in her hand, a court order. But you know, these are symbols. They're symbols that people don't really spend a whole lot of time thinking about. But it is interesting that as we think about symbols of justice, no one ever says, how come it's not a man? And nobody ever says, why is she white? You know, there's so many questions that we assume, and so the answer to your question is, I think we should leave it alone.
Michael?
I'd either a bulletproof vest or a shield, maybe a taser, and tighten the blindfold a bit, because fearlessness, you know, a willingness to be fearless and not have the judiciary be politicized. And that's our Canadian judiciary. It is, by and large, not politicized, and more often than not, fearless. And that we not become more American in our judiciary and in our justice system would be, and therefore tighten the blindfold and reinforce the armaments so that there's a fearlessness there. And you know, the part about the justice system that personally makes me the most nervous is where you don't feel like there's an independence, that the judge might be unwilling to be a little unpopular, and might be unwilling to be unpopular within their community with respect to a particular injunction and so on, or really wants to get that profile done in the local paper and loves the popularity that comes from a particular decision. It's when you lose that independence and that blindfold, I think, that the justice system becomes literally corrupt. So I tighten up the blindfold and get her a taser, and don't worry about the scales.
What's the point of the blindfold? Can you guys figure it out?
Yeah, but it's blind. I think blind to talk show hosts and politicians.
Do you know what it means?
It's an outrage.
No, I think it does mean that you are blind to extraneous things like wealth and influence and
Yeah,
power.
same thing. Yeah.
It's a bit about what the Globe editorial was about in saying that, jurors are capable of, but in this case, the blindfold helps to, keep out things that extraneous, as you said, considerations. But I guess we'll never know.
Not all of the statutes have blindfolds, and I think the one in front of the
Yes.
Supreme Court does not have a blindfold. Am I
have
right
no
about
idea.
that? Well, you mean you didn't even examine it in preparation for this panel?
I think he's got a blindfold. I think
Okay,
you're
easy.
you're
yeah.
projecting
Yes, I
a
did, but I
blindfold.
forgot what I saw.
I will never appear there at this stage of my life. You might, so I would just. He's okay. Meredith Bacall, where are you? There she is. Okay, Meredith, we will let you ask your question, if you would, please.
So, with the prorogation crisis still fresh in Canadians' minds, and with the newfound popularity of the royal couple, William and Kate, how do you see the role of the Crown and that of the Governor-General evolving in the coming years? Is there room for a king and queen in our constitutional future?
Thank you very much, Meredith. Peter, you get to start.
Well, it is true that William and Kate have delivered a terrible blow to the Republican movement in Canada, and the movement was pretty weak, before the blow was delivered. So I think that the reality is that we probably will have a king and a queen in our future. But my own view is we don't need them, and we shouldn't have a king or a queen. We've already domesticated the process of appointing the Governor-General. The Governor-General's appointed by the government of the day. That probably should be replaced by some form of election. But there's really no need for a monarch, particularly a monarch residing in England. And so my view is there's no rational room for a king or queen in the future of Canada.
Do you wish to comment on this, Madam Justice? or-
Absolutely not.
Okay. All right. Well, then it would fall to you, Mr. Bryant, to comment on this.
I think, I'll think politically for a second. If this discussion was taking place in the province of Quebec, the view would be quite different. So I think that, the feeling, I think, would be different. I'm with Peter Hogg here. I think that there's, it just is moving in a direction in Canada's history that we're moving away from. And now, which is not to say that I wouldn't be, willing to serve for a term as, lieutenant governor,
King.
Yeah, king, I do that. But then, you know,
Princess?
pull up the ladder jack after that. So, yeah, that's it. That's my
I'll
answer.
leave it to you two at some other panel to explain the system that would work better. Now, what we will do, since you deferred on that question, is there was one that was sort of a bonus question, and we don't have time to have all three, but we thought we might ask you if you'd like to take a shot at this one, which is, it was a question submitted, it doesn't have a name here, but what new legal rights do you think the Osgoode class of 2022 will be talking about most when we come together to celebrate the 10th anniversary of the Osgoode building? Is there a legal right, a legal principle, something that's going to have evolved in the law over that 10 years from today that we might be talking about?
Yes, and it's search and seizure.
Guys,
Is your name Rosie?
Equality, freedom of association, freedom of expression, that stuff will all be settled. But search and seizure is going to go on because it's reliant on technology. New technology for listening in to people, searching their homes. It's going to go on and on. It's going to be fascinating. It'll be the only thing people are talking about in 10 years.
Justice
I
Abella, what do
think
you
they'll
think?
be talking about how men still feel that they run the world. Yogi Berra said predictions are hard to make, especially about the future.
That's your answer?
No, my answer is that we're going to be, everything will be different. All the laws will be different in just about every area. Family law will be different, privacy will be different, criminal law will be different. Every single area of law will be different. What will not be different is how we settle civil disputes.
Will there be a faster pace of change in the way the laws change, the laws that you talked about in all those different areas?
You know, everything, if you look at 68, look at what's happened to every single area of law. We couldn't have even had an anticipation that we were going to have, you know, when you first came up here, husband and wife were one person in the law. Did we think there was going to be a revolution in family law? Did we think there was going to be a revolution in technology? Did anybody mention the word globalization except Harry Arthurs? I mean, we are just kind of in the front row of watching a universe spin out of control. And I think to try to predict all the things, how everything is going to change is probably not a wise thing. But everything will change 10
All
years
right.
from now.
Would be unfair not to give you a very quick word, Michael.
There'll be less rights talk. The reference was to what rights we'll be talking about. I think there'll be less talk about rights and less of a focus on rights and more of a focus around responsibilities of institutions and those who are at the other end of the those who are being targeted by the protests in Occupy Toronto right now.
May I extend your thanks to the panelists for their contributions and for being so timely in how they answered the questions. And I think before I hand the mic back to the Dean, we're going to invite Nicole Walton, Erica Keating, Jacqueline Kagundu, and Meredith Bacall up to receive some recognition for submitting the questions that were picked.